an individual arbitration provision which gives an individual investor the right to bring a claim. And so you start with the treaty, and then you go from there. Now, the point in Legrand and Avena was a little bit more esoteric, because there's no question that bilateral investment treaties give individual investors rights. The question is, in the difficult case, are those the rights of the investor? Are they the rights of the government, tracing back to diplomatic protection and the law of injury to aliens? And then the investor is merely given the right for convenience to enforce the rights of its sovereign. And I think that's the principle that was addressed and perhaps resolved in Legrand and adopted by the English court in Occidental versus Ecuador. But the Supreme Court, and not unreasonably, I think, said if you want to figure out if a treaty is enforceable by a particular kind of person, be it a state or an individual, the first place that you would look is specific enforcement provisions which give a right to that person. And that's what they did, for instance. I think it was a not the best example they used. They in articulating their view that the ICJ decisions are not self-enforcing, they refer to the fact that there is an enforcement provision which refers you to the Security Council, and that's a not an unusual view, which is you have state-to-state disputes. Those can become political. Sovereigns may not want to have them judicially enforced, so you are thrown back to sort of the ultimate kind of state-to-state kind of forum. The Supreme Court referred to Chapter 20 of the NAFTA, which also has limitations on the remedy available in state-to-state disputes. But I think, again, treaties have lex specialis, and where a treaty says, here is your right, and here is your remedy. And your remedy in the case of a trade agreement may be limited to suspending your application of the same benefits against the offending party. In other words, the other side may violate the treaty, but the only remedy is that provided in the treaty. So you have basically a lex specialis provision there. And the interesting thing to me is that the ICJ is applying, in Avena and Legrand, general principles of international law going back to Chorzów Factory on remedy, but the Supreme Court is invoking a treaty provision which has very specific provisions defining exactly what the remedy is and who is entitled to invoke it. I hope that's helpful.
Other questions? Yes, sir.
What's the effect of customer law? Obviously, you can now imagine a situation where Congress adopts laws each time there is what comes under international law principles.
I actually think that the Medellin line of cases doesn't have any implication for customary international law. That was never an issue because we were relying on the explicit text of a treaty.
I mean, that's the same with Boumediene. It, did not get into customary international law. I mean, I think if you go back to the Hamdan decision, one of the things the State Department was surprised about is we thought if the court were to conclude that Common Article 3 applied to the conflict with al-Qaeda, they would have come at that from the conclusion that Common Article 3 was customary international law, as opposed to this, what we think is a pretty strained treaty reading to conclude that it applies to that conflict. But custom has never really been addressed in these line of cases.
Well, we're a little over time, but I don't want to cut off anyone if there's any other questions. If not, I just want to really thank this panel. It's been wonderful. I think uniformly really informative. Let's give another round.
Back to prepare for my damages hearing.
Judge Garland, he just calls him as he sees him, right? Or hot? Yeah.